Greetings. In this presentation, we will be discussing about trademarks and the laws governing them. Meaning of a trademark: any symbol, name, figure, letter, word, or mark adopted and used by a manufacturer or merchant in order to designate specific goods and to distinguish them from those manufactured or sold by others. A trademark is proprietary and is usually registered with the Trademarks Office to assure its exclusive use by its owner or licensee. A trademark is recognizable sign, design, or expression which identifies products or services of a particular source from those of others. Trademarks used to identify services are usually called service marks. The trademark owner can be an individual, business organization, or any legal entity. A trademark may be located on a package, a label, a voucher, or on the product itself. For the sake of a corporate identity, trademarks are often displayed on company buildings. We will now discuss the importance of a trademark. Trademarks are an effective communication tool. In a single brand or logo, trademarks can convey intellectual and emotional attributes and messages about you, your company, and your company's reputation, products, and services. Your trademark doesn't need to be a word. Designs can be recognized regardless of language. The Nike swoosh design is recognized globally regardless of whether the native language is Chinese, Japanese, French, Spanish, Russian, Arabic, or English. Trademarks make it easy for customers to find you. The marketplace is crowded and it's hard to distinguish your business from your competitors. Trademarks or brands are an efficient commercial communication tool to capture customer attention and make your business, products, and services stand out. Because of the reputation earned by you, customers viewing a trademark immediately know who they are dealing with and are less likely to look for alternatives. Your brand could be the critical factor in driving a customer's purchase decision. Trademarks allow businesses to effectively utilize the internet and social media. Your brand is the first thing customers enter into a search engine or social media platform like Facebook or Twitter when looking for your products and or services. Higher traffic on a website or social media platform translates into higher rankings, bringing even more traffic, more customers, more popularity, and eventually more brand recognition. Trademarks are a valuable asset. Trademarks can appreciate in value over time. The more your business reputation grows, the more valuable your brand will be. Trademarks provide value beyond your core business. Trademarks can lead the way for expansion from one industry to another, such as from personal care to cosmetics to clothing. If you desire it, your trademark can lead to the acquisition of your business by a larger corporation. Trademarks are a property asset, similar to real estate, that can be bought, sold, licensed, or used as a security interest to secure a loan to grow your business. Trademarks can make hiring easier. Brands can inspire positive feelings in people's minds. As a result, employment opportunities are more attractive to candidates applying in companies to which such brands belong. Employee retention can be higher if employees have positive feelings for the brand and the products and services offered under that brand. Trademarks are a bargain to obtain. The Indian Trademarks Office charges as little as 4,500 rupees to obtain trademark registration, and only a certain amount as fees every 10 years after registration. Trademarks never expire. Your trademark will not expire as long as you are using it. Registration of a trademark is renewable every 10 years, with no restrictions on the number of times a trademark registration may be renewed. Some of the most recognized brands today have been around for over 100 years. Mercedes was first registered in 1900. Pepsi Cola was registered in 1896. Brands are a critical asset. Do your due diligence before investing a lot of time and money in launching a new brand. Be sure the brand fits your company. One must obtain a clearance search to make sure their new brand is available and doesn't infringe anyone's prior rights. Failing to research a brand before adopting can lead to denial of registration by the Trademarks Office, or worse, a cease and desist letter from another brand owner. Spending the time and money up front to determine whether a brand is available will help avoid the very high cost of a dispute or litigation. Keep in mind that the more unique your brand is from others in your industry, the easier it'll be to protect it. Choosing a name and logo that distinctly identifies your business will protect it from competitors. We move on to discussing the functions of a trademark. The most important and primary function of a trademark is that it identifies the product or service with its source and origin. It allows consumers to distinguish goods and services from those of another by affixing a trademark to the goods or services. It guarantees the quality of goods or services. It helps in advertising the product or services. It creates an image of the product in the minds of the public, particularly the consumers or customers or the prospective consumers or customers of such goods. We will now elaborate on the legal requirements for registering your trademark. There are four basic requirements for filing a trademark or service mark with the Trademarks Office. The trademark must be applied for under the actual owner's name. The owner of the trademark is the person who controls the nature and the quality of the goods sold or the services rendered under the trademark. The owner can be an individual. The owner can also be a partnership, corporation, or an association. If the owner is a corporation, then the applicant's name is the corporation's name. The applicant must specify what type of entity it is, whether individual, corporation, or the like, and its national citizenship. The application must be based on actual use or a real intent to use the trademark in commerce. You must submit a drawing of the trademark and a specimen of the trademark when the application is based on actual use. A specimen is a real world example of how the trademark is actually used on the goods or in connection with the service. Labels, tags, or containers for the goods are considered to be acceptable specimens of use for a trademark. For a service mark, specimens may be advertising, such as a magazine ad or brochure. Labels and photographs of packaging are examples of acceptable specimens. We move on to discussing the criteria for selecting a good trademark. A trademark must be chosen carefully. If you are launching a product and adopting a new trademark, please bear in mind that the scope of legal protection you would obtain depends on the type of trademark chosen. The most common mistake is to choose a word that is descriptive of the goods or services. People do this in the belief that the consumer will know straight away what the product is or for what the service is rendered. The same result can easily be obtained by combining a distinctive and fanciful trademark with a word which indicates the goods or services. For instance, Kodak film. Descriptive trademarks are difficult to register and enforce. Although it may be easier to market such products at inception, such trademarks are offered the least amount of protection, and therefore, in the long term, it would be difficult to stop your competitors from using the same or similar trademarks. A better strategy would be to adopt a coined word, which has no reference to the goods or services upon which it would be used. For example, Canon. Another option is to adopt an arbitrary word, which has no relevance to the goods or services upon which it is used. For example, Apple computers or Lotus software. One should avoid using superlative or laudatory words, for example, premium, gold, or deluxe. Also, descriptive words such as coffee shop for coffee bars or coolers for refrigerators should also be avoided. It is advisable that trademarks which are confusingly similar to existing trademarks should be avoided. One must avoid words which have direct reference to the character or quality of the products or services. For example, best, easy, or super. Using common personal names or surnames should be avoided. Such names are registrable only if they have acquired distinctiveness through advertisements and long use. Well-known geographical names such as Swiss chocolate or USA pizza are also not registrable. We now move on to discussing the elaborate procedure of a trademark's registration. To first make sure that your trademark is available for registration, a thorough trademark search is to be conducted in the database of the Trademarks Office. Such search can be conducted on the online database of the Trademarks Office, which is easily accessible on the IP website. Upon conducting a thorough search and making sure that your trademark is available for registration, you may proceed to file a fresh trademark application for registration. This step has been simplified due to online filing of a new application on the IP website upon payment of prescribed fees. Immediately after filing for a new trademark application, an application number will be allotted to your trademark. This number will be used to identify your trademark along with its details throughout its registration process and even after it has acquired registration. After the application number has been allotted, the application will be sent for Vienna codification. The Vienna codification is done by the Trademarks Office so that trademark searches can be conducted for artworks or logos. Once the Vienna codification is done, the application undergoes formalities check. If the application has not been cleared from the formalities check, the applicant of the application is asked to provide all formalities so as to proceed the application further. The next step after passing formalities check is the examination of the application by the trademarks examiner. The examiner will either accept your application and allow it to get published in the trademarks journal, which is released every week, or raise objections which have to be overcome. A hearing may also be called for so as to overcome the objections raised. If the examiner is convinced, he may then proceed the application for publication or refuse the application altogether. Once the mark gets published, a third party may oppose the same within a period of 4 months of its publication. If 4 months have passed since publication of the mark and no opposition has been filed against it, the mark may then proceed for registration. However, if the mark has been opposed, then such opposition has to be overcome in order to proceed the mark for registration. Once the opposition is overcome, then the mark proceeds for registration. The registration of a trademark is valid for a period of 10 years. The registration can also be renewed every 10 years with no restrictions on the number of times the renewal is filed. We move further to the topic of government formalities and fees. The new Trademarks Rules 2017 have been introduced and have been enforced from March 6, 2017. As per the new rules, online filing has been encouraged by giving 10% discount on online filing fees in comparison to manually filing applications. Many new provisions have been introduced so as to simplify and speed up the process of a trademark's registration. Reduction in the number of forms. Where there was 74 forms for each kind of application, the new rules have drastically reduced the number of forms to 8, with subcategories in each of the 8 forms. Categories of applicants. The basic requirement for applying for registration of a trademark is the applicant under whose name the trademark will be applied and thereafter duly registered. The new rules have introduced categories of applicants, which are mainly two. The first being individual startups and small enterprises, and the second being others. Depending upon the type of the applicant, the fees for the application will be determined, a provision which was not present in the old rules. The fees for applicants who fall under the first category mentioned above is 50% of the fees for applicants falling under the second category. To elaborate, whereas the fees for filing a new trademark application for a startup is Rs 5,000 manually, the fees for filing a new trademark application for a large enterprise is Rs 10,000 for filing a manual application. Shorter procedure of trademark opposition. Under the old rules, the procedure of a trademark opposition, though elaborate, was time-consuming and would take approximately 5 to 7 years to complete, which would consequently delay the registration or refusal of the trademark. Under the new trademark rules, the opposition procedure has been considerably simplified. Provisions such as reduced period of taking adjournments during the opposition proceedings, reduction in the number of times evidence may be submitted by either parties to the opposition, and limiting the number of extensions to be taken for submitting any evidence or further evidence to only 2 have been introduced. Such simplification will ensure that the opposition proceedings are not delayed or postponed. Reduce time spent on the opposition by the parties, their respective attorneys, and the trademarks registry. Expedited procedure of application. A relatively new concept incorporated in the new rules. The process of expedition would mean to fast-track the process of registration of a trademark application. One can opt to expedite their application upon payment of additional prescribed fees, which is 4 times the fees of filing trademark application. This means that the application would be processed much faster at every stage until registration, unlike the old rules where the expedition of the process took place only till the stage of examination of the trademark application. Online communication for registration. As per the new rules, any communication made through email would be considered as complete service of that communication. In such a case, the practice of providing documents through post thereafter will not be followed, thereby ensuring that a trademark registration is not delayed simply because the documents in connection thereto were not sent or not received or returned due to some reason. Accordingly, submission of a valid email address of the applicant along with the postal address has been made compulsory. Change in determination of well-known trademarks. New rules permit applicants to apply for their trademark to be recognized as a well-known one. In simple terms, a well-known trademark is one that is well recognized and any infringement could result in misleading the public, something like the half-eaten apple symbol or three slant bars from a popular sportswear manufacturer. This is a positive step as it will allow bigger brands, especially ones with trans-border reputation, to file applications claiming that they have achieved the standing of a well-known mark. Inclusion of a sound mark. The definition of a trademark as per the Indian Trademarks Act 1999 included a sound mark provided it is represented graphically, which means that the sound mark which is applied for registration should be represented in musical notes and not the real sound per se. However, the new rules have introduced the provision of applying a sound mark in an MP3 format, such sound not being longer than 30 seconds. With the growing recognition of brands being identified due to a trademark sound, this addition is pleasantly welcome. Not only will an applicant be able to apply for a sound mark through graphical representation, such sound mark can directly be applied in MP3 format, provided it does not last beyond 30 seconds. This provision will enable the applicants to register their sound mark in its true form, as previously even the registration certificate of the sound mark would contain only the graphical representation of the sound mark, a process which lacked practicality. Inclusion of sound mark in MP3 format also indicates promotion of the Digital India program. Video conferencing. In order to save time and expedite the process of registering a trademark, hearing through video conferencing and any other visual communication has also been introduced. A welcome change indeed. This facility is beneficial in situations where the applicant or the applicant's attorney may be unable to appear physically for the hearing, yet attend the hearing through audiovisual communication or through video conference, thereby preventing any delay or adjournment to proceed a trademark application for registration. Submission of statement of use. A practice followed in the US, this provision has been newly introduced in India to bring clarity with regard to a use of a trademark. The new rules have made it compulsory to provide a statement of use along with the affidavit and supporting documents to claim that the trademark is in use while filing a new trademark application, as opposed to the earlier practice where an affidavit and supporting documents were to be submitted after the trademark application was examined and if it were asked to be submitted by the learned examiner or if such mark were opposed. Period of filing renewal fees of registration. Where the period of filing for renewal of a trademark registration was 6 months prior to the date of expiry of such registration, the new rules have amended the period of filing renewal request as early as 1 year from the date of expiry of such registration. This provision gives more flexibility to an applicant to renew the registration of their trademark and also hopes to prevent any delay which may be caused in filing renewal request for a trademark's registration within the stipulated time. We move ahead to discuss the time period of a trademark's registration. Registration of a trademark takes a minimum period of 6 months and a maximum period of 2 years in case of a smooth registration. Trademark registration is renewable for a further period of 10 years from the date of its registration validity, provided the request for renewal is filed within the prescribed time. A registered trademark is protected in perpetuity, subject to periodic renewal and continuous use. We move on to discuss the difference between a passing off action and infringement. Passing off action arises when an unregistered trademark is used by a person who is not the proprietor of the said trademark in relation to goods or services of the trademark owner. Passing off in India is a tort actionable under common law and mainly used to protect the goodwill attached with the unregistered trademarks. It is founded on the basic tenet of law that one should not benefit from the labor of another. Section 27 of the Trademarks Act 1999 provides that no infringement action will lie in respect of an unregistered trademark by recognizing the common law rights of the trademark owner to take action against any person for passing off their goods, services as the goods of another person or as services provided by another person. Infringement of a trademark. Trademark is said to be infringed when a registered trademark is used by a person who is neither the registered proprietor nor the licensee of the said trademark in relation to the goods or services for which it is registered. Trademark infringement in India means violation of the exclusive rights granted to the registered proprietor under the Trademarks Act 1999 to use the same in relation to goods or services in respect of which the trademark is registered. Sections 29 and 30 of the Trademarks Act 1999 lay down the provisions for protection of a registered trademark in case the same is infringed upon by a person not being the registered proprietor or licensee. We now move on to discuss the case study of ITC versus Britannia Biscuit. Setting aside an order of interim injunction passed against Britannia Industries, restraining it from using a packaging wrapper for its NutriChoice Digestive Zero biscuits, the Delhi High Court has observed that the appropriation of and exclusivity claimed vis-a-vis a get-up and particularly a color combination stands on a different footing from a trademark or a trade name, and an interim injunction order can only be passed when it is established, maybe even prima facie, that the color combination has become distinctive of a person's product. A division bench comprising Justice Badr Durraiz Ahmad and Justice Ashutosh Kumar held that colors and color combinations, unlike trademarks and trade names, are not inherently distinctive and therefore not easy for a person to claim exclusivity over a color combination, particularly when the same has been in use only for a short while. ITC had filed said suit seeking an injunction restraining Britannia Industries Limited from violating its purported rights in the packaging or trade dress of its product Sunfeast Farmlight Digestive, all good biscuit by allegedly using a deceptively and confusingly similar trade dress for the latter's NutriChoice Digestive Zero biscuit. An interim injunction order was passed against Britannia Industries. The court said the combination of yellow and blue as used by ITC for Sunfeast Farmlight Digestive, all good biscuits, has not become so identified with its goods so as to become a badge of its goodwill. Some interesting facts. This is probably one of the most famous logos in this category. Just in case you're somehow out of the loop, look between the E and X of the word FedEx. In the white space, there is an arrow that sublimely represents speed and precision. Famously known for its 31 flavors, supposedly so that a customer could have a new flavor every day of the month, Baskin-Robbins makes it known in their logo. Thank you.